right, we are in our summer forms series in the month of, oh, what is this? July. In the month of June, we covered all of the new forms changes. So if you want to catch those on replay, those are recorded. We talked about the BRBC as well, and now we're diving into the residential purchase agreement. And throughout the month of July, we are going to be diving into these buyer forms. So my goal today is to wrap up the RPA, the residential purchase agreement, and then starting next week, we'll dive into the forms that are connected to that residential purchase agreement, things that you need for your buyers. Does anybody have any questions before we jump in and pick up where we left off? All right, continuing right along. Watching this on replay, you can feel free to reach out to me directly with any questions that you might have or throw them in the chat boxes or the comment section. In this section of the grid of the residential purchase agreement, again, we're in section 3, item Q is where we're going to pick up, which is the allocation of costs. Obviously, as with the other ones, the first column is your reference column. So it's 3Q1, 3Q2, 3Q3, 3Q4, right? And then we have our paragraph number. So if we want more information on the natural hazard zone disclosure report, including tax information, which is the item here in Q1, we would go to the residential purchase agreement sections 10A and 11A, where we would find more information regarding that natural hazard zone disclosure. This section here, Q, is all about who's going to pay for what, and not everything applies to every transaction. So in the first one, the NHD report, generally speaking, in the state of California, the seller is required to provide a natural hazard zone disclosure statement as part of the transaction. That is generally done as a natural hazard zone disclosure report. They kind of pass the buck off to somebody else to provide those disclosures for you. So generally speaking, this is a seller paid report. And then you would want to specify the company. If you have a specific company you like using, they offer protections, they go deeper or wider in where they look for those natural hazard zones. That there. If you don't care and it's maybe the seller already has one in their home light listing management file, don't put seller's choice here. That's actual company of an NHD report. So put something like seller to choose provider. Okay, so we can do that as well, but you can feel free to specify a specific company in that line item. Okay, so item descriptions here. Who pays? If both is checked, notice here it tells us if both is checked, cost to be split equally unless otherwise agreed. So if I checked buyer and seller, it won't actually let me even do that one here. But if they, oh, sorry, I didn't share my screen. Thank you. Sharing screen. Hold on. Minor details. Minor details. Let's see here. Desktop 1. Share that. All right, give me just a second to get my screen back in order now. And pull this one up. All right, so now hopefully you can see it. I'm sorry for not sharing my screen previously. All right, so there is that section there. Column 1, reference. Column 2, paragraph that you can find more information. Column 3, item description. Paragraph 4 is where you're going to identify who pays and then any additional terms. So there's additional options on your NHD report. You've got your environmental option, and then you also have other. So maybe if you wanted a, I don't know, a clue report or something, there's several providers of NHD reports offer supplemental reports that go along with them that dive deeper into one area. Then you could include that and specify it on this line. Okay. I usually ask for the environmental report. So that's your NHD report. And again, generally speaking, that's a seller paid item. The next one is the optional wildfire disclosure report. Okay. You don't need this for every property. We really just need it for if it's in a high fire hazard or very high fire hazard severity zone, then you may want the optional wildfire disclosure report. There's a couple of providers there, and if it's not, come down here and put that in there so that these line items that say click here to select wildfire service provider and whatever this one said here, those used to, when you went to put it into signatures or print it, those would disappear. But I've noticed on a couple recently, they aren't automatically vanishing anymore. So you do want to go in there and put not applicable if you're not going to use it and you don't need it. So there's lots of wildfire disaster, wildfire disclosure reports available through like your NHD providers. Okay. So there's that. And you can, if you want, you can delete that so that it's nice and clean if you didn't want it. Q3 is for additional reports. There's blanks here. You can fill in those line items with anything that you want the seller to pay for. Generally speaking, we don't put buyer paid for reports on the residential purchase agreement. And here's why, and we need to be careful even about seller paid reports, because if we say, hey, we want the seller to pay for the pest inspection, right? Or wood destroying organisms, and we specify either the buyer or the seller. Now the lender is going to see this residential purchase agreement and go, hey, we saw that there was a pest inspection requested. The seller was going to pay for it. We want a copy of that pest inspection. Now the lender, even if it's a conventional lender, is probably going to require Section 1 pest clearance, if not the entire thing, to be clear. So we don't want to put things on here that's going to cause red flags for the lender, or we just need to be aware of that because it is going to cause issues anytime we put any sort of reports on here. Your NHD report, not really. Lender's going to get a copy of that anyways, because they're going to pull whether it's in a flood zone or a high fire hazard severity zone. They will want that information. So we don't always send them the NHD report, but they pull that information through their own channels. But things like pest, septic, sewer lateral, right? Those things, we may want to put that on there. Now, keep in mind here that on Q3, if it's required as a point of sale requirement, we're not going to put it on Q3. Okay, this is just optional reports that we want covered by, again, generally speaking, we just put this we want the seller to pay for it here. Okay, and then there is a line for both here. So we could put, hey, we're both going to pay for it. It won't let you check both buyer and seller. So you check the box both. And that just means that, hey, if both is checked, right, where that optional is, that means that we're going to split it equally 50-50 unless it's specified other words, which is what this line item is for. You've seen a lot blank in regards to what specifically? All right, Zoom user, I will watch for that. Oh, their investigation. Yeah, we don't have to fill anything in here. Again, we want to fill out, generally speaking here, you're going to have the natural hazard zone disclosure specified. Beyond that, for our investigation reports and inspections, we're not going to put them on here unless we want the seller to pay for it. So if it's inspections and investigation, the buyer's going to do the whole house inspection, the pest inspection, the whatever that might be, roof inspection, pool inspection. We're not going to put those on our residential purchase agreement. We're just going to leave this section blank. Okay, because generally what happens here is if we put something here, lender wants a copy of it. So only put what we want to submit to the lender on your residential purchase agreement. Q4 is smoke alarms, carbon monoxide detectors, and water heater bracing. Who's going to pay for that? Generally speaking, for most of our residential properties, sellers going to pay for those items. They're kind of anticipating them. Most of the time they're already done and the seller expects to pay for those. They are a point of sale requirement, which is why in our time frames above, it asked, how many days before we had those installed and ready to go. And I usually put that down to about 3 days here in this section here. install smoke alarms, carbon monoxide detectors, and water heater bracing. I want it done before the appraisal goes on, so I usually shorten it to 3 days. And then down here is where we specify who pays for that. And again, most of the time, it's going to be the seller. There's a few properties where the buyer may need to pay for that if it's not done. Sometimes if we have like bank-owned properties or properties in a short sale situation where the seller just has no funds to do anything, or sometimes if it's owned by like a large corporation or something, then they'll say, hey, we're not doing that. You can take care of that. But for the most part, 99% of the time, the seller is going to pay for that and take care of making sure that's done. Now, Q5, it's our government required point of sale inspections and reports. This is why I said, hey, up here on Q3, if it's required by the city or the county or the state, we don't put it on Q3 because that's covered by Q5. So this would be like if you are in a woodland and you have your fire suppression system has to be inspected prior to the close of escrow. If you're in the Bay Area, you have that sewer lateral inspection that's required. If you're in Davis and you have your pre-sale inspection done, that's what all fall under this government required point of sale inspections and reports. Okay, so anything that's required as a point of sale, whether it's city government, county government, or state government, that would go here. You're going to specify who's going to pay for those. Generally speaking, for the most part, seller usually pays for those point of sale inspections. Okay, the next section down here is Q6. That's government required point of sale corrective or remedial actions. Now, if you're in an area where there's not any government required point of sale inspections or reports, you can leave this blank. Okay. I usually just mark it seller just in case something were to come up and it was required, then we have it marked as seller. And then oftentimes I leave this blank. Now, if I lived in a place like Woodland or Davis or the Bay Area or wherever there's like sewer lateral, something specific required, I might specify here that, hey, whatever corrective action needs to be done, seller agrees to take care of that. You may get countered on it because they may say, hey, we don't want to agree to that up front because we don't even know what that dollar amount would look like. If there is something like maybe we've got a sewer lateral inspection that's required and seller says, no, I'm not going to agree to the corrective or remedial actions only because there's no price tag on it, right? Like we don't even have the inspection done, so we don't know what that cost is. And if it's going to cost us $20,000, we may not want to sell the property if we have to pay for it, right? So this is kind of Q6 is some gray area as to whether you check it or not check it. I personally, unless there's something specific, hopefully the seller already has those inspections, anything done up front. But if they don't, you could specify seller's going to do any corrective or remedial actions. As a listing agent, if a purchase contract came through and I wasn't sure what was in that inspection or report yet, and it was specified the seller was going to pay for any corrective or remedial actions, I would counter that, hey, seller's not going to blanket statement pay for those items. We're going to wait and see what's in the inspection reports and negotiate from there. Again, only because as a seller, I wouldn't want to lock in to, $20,000, $30,000, $40,000 worth of repairs when I don't know what that price tag looks like. Okay. So hopefully that made sense to everybody. I usually leave this section blank on my residential purchase agreements. The escrow fee is Q7. Okay. If you want to know who's supposed to pay for what, a good place to go to, hold on, shrink this window down. Let me grab another one. Maybe. There we go. All right. If you go to, I know that Old Republic has it, so ortconline.com. That's Old Republic Title Company. Not saying you should or shouldn't use them. I'm just saying their website and their free tools are great. So they have a Who Pays button. So down here on this dark blue toolbar on the left-hand side, there's a Who Pays button. And if we click on that, it'll take you to the next screen. You plug in the property state, you plug in the property county. Like maybe we're going to go Solano. We're going to pick a city. We're going to go Vacaville. We're going to put in the approximate purchase price. And we're going to hit submit. Again, this is their free tool. It says, hey, title fees, usually paid by the buyer. Escrow fees, typically paid by the buyer. The documented transfer tax, that's going to be your county transfer tax. Seller generally pays. And the reason it asks for the purchase price is it automatically calculates what that dollar amount is and then tells you if there is a city transfer tax and who would pay for that. Okay, so I like their site just because it's free. It's a great tool. And it helps you, especially if you're doing business in an area you haven't done business before. Now you can fill that out. Okay, so here we are at escrow fee. So per that, if we were in Vacaville, buyer's going to pay. Owner's title insurance policy, buyer. You can specify the escrow holder. In fact, in the state of California, it is the buyer's right to specify the escrow holder. Okay. In Northern California, our title and escrow are together. Okay. So it's actually one of them, escrow or title. I think it's title is legally can be chosen by the buyer, where escrow is, I think, it can be anybody choose. But because in Northern California, our escrow and title are tied together at the same place, it's the same thing. Okay. In Southern California, they're separate. So you have title companies and you have escrow companies, and they're separate. So you would specify them. That's why we don't live in Southern California. It's also a lot more expensive because it's two companies. So here, escrow and then specify who you want. And then the title company, you would specify if it was different from the escrow holder. Now you may make choices here, like it may be in the listing, like, hey, we would like to use Old Republic or Placer Title or Fidelity, because there's probate involved and they already have all the details, or there's solar involved and they've done all the back legwork for us, or it's a short sale. So there might be a reason where they've pre-opened escrow and they want you to use their escrow company. And they'll ask for that, and you can decide whether or not you want to accommodate that or not. Totally up to you. And it also depends kind of a little bit more on whether it's a buyer's market or a seller's market. If it's a seller's market, we're getting multiple offers in, and it's between your offer that's wanting to move title companies and another offer that's very similar to yours, but keeping their title company. They may make a decision based on that. So just be aware of those details. There's a button over here in the far column that says each to pay their own fees for escrow fees. That doesn't exist in our area. So please don't check that box. Title and escrow is going to kick it back to you and go, what did you mean? Are we splitting it 50-50? What are we doing? So if we want to split it, we're going to use both. And again, anytime we check that both box, it's assumed it's a 50-50 split. Okay, it's actually stated in the top of the column. Otherwise, we would specify buyer or seller. And you could specify like a 60-40 split. Okay, so whatever you want to do there, but that's the title and escrow, Q7 and Q8. The buyer's lender's title insurance policy. So we're going to have an owner's title insurance policy, which ensures that the title is free and clear for the owner from the date that they record on that property and take possession of it. A lender is going to require a separate title insurance policy. It's cheaper than the owner's title insurance policy, but it protects the lender in this case, not the owner. And unless otherwise agreed, buyer shall purchase the title insurance policy insuring buyer's lender. That's buyer's responsibility. Okay, so there's no options there. Q10 is the county transfer tax. That was that one, the documentary transfer tax. That's the county. So you would check buyer, seller, or both. City transfer tax, buyer, seller, or both. And again, we generally don't check this if there is no city transfer tax. It just kind of makes you look a little crazy. And if you say, hey, seller's going to pay for that city transfer tax and there is no city transfer tax, the listing agent is just going to look at you like, oh man, we got another one that doesn't know what they're doing. So don't check that box if there is none. Your HOA fee for prepping disclosures is paid for by the seller. And the HOA certification fee is paid by the buyer. So the documents required to the seller to provide to the buyer as part of the transaction. That's going to be paid for by the seller. Your HOA certification fee, that's actually required by the lender issuing the certification if they need that. So that's why it's paid for by the buyer. It's a lender requirement. HOA transfer fees. Okay, who's going to pay those transfer fees? And it does say in our additional items over there, unless otherwise agreed, seller shall pay for separate HOA move out fee and buyer shall pay for separate move in fee. Applies if separately billed or itemized with a cost in transfer fee. So if it's broken down by move out and move in, then each would pay their own. But otherwise, we need to specify here who's going to pay those transfer fees. Okay. Private transfer fees is Q15. And it specifies here the default is that the seller is going to pay for any private transfer fees. Okay. Unless checked, buyer or both, and then are specified. So private transfer fees, what would those be? Obviously not the HOA fees because we already covered that. But this would be sometimes we've got rural properties that have like a shared well and there's a transfer fee. Maybe the property has solar and there's a transfer fee, which is often the case to transfer like the monitoring and stuff of that to the new human. That would be a private transfer fee. That would fall underneath there. So just know that's there and it defaults to the seller. Q16 is the septic, well, propane tank, and property boundaries survey. And if you check that box because the property does have a septic, a well, or propane tank, or property boundaries, you want a survey on it, it's going to include that new form that was just released as part of our forms transfer, our forms release in June, the SWPI-C, and that's your septic, well, propane tank, and property boundaries inspection and allocation of costs addendum. So even if there's just a well without septic or propane tank or anything, we would still include that form and just identify the well portion of it versus the other items. Okay, if buyer's going to pay for all of these, we're not asking the seller to pay for anything. Don't check the box there because if we check that box and include that septic, well, propane tank, and property boundaries inspection and allocation of cost addendum, lender's going to want to see any inspection reports listed on that document. So again, if we have a property, let's say there's a septic and a well, and we're going to have them both inspected. Buyer's going to pay for the well inspection. Seller's paying for the septic inspection. We want to make sure we ask for that septic. We would check the box for the SWPI. And then on the SWPI, we would check the box for septic that seller's going to pay for the inspection and pumping of that septic system. Generally speaking, country properties, you've got septic and well. Seller generally pays to pump their own poop, which is your septic inspection and pumping. Buyer usually pays for the well inspection. That's totally up to you and how you want to negotiate that. I would not put the well on the SWPI if the buyer is going to pay for it as part of their regular inspections. Because if we put it on the SWPI and we've identified that we include the SWPI on the residential purchase agreement, lender is now going to want to see a copy of that well inspection. If the buyer says that they want the items to go to the lender so the property is in tip-top shape, you can let your buyer know that they can absolutely submit those to their inspection reports. I still wouldn't specify them here on the residential purchase agreement. You can let your buyer know that they're welcome to submit those to their lender, but chances of the seller taking care of every single line item listed on every single inspection report is probably going to be slim and none. And chances are that by doing that, they're going to just be out extra money because they will have paid for inspections and reports that now the lender has killed the deal because the seller is refusing to pay for who knows what the little line, replacing all the screens that have holes in them. Okay, so you may run into an issue like that. And not only do you run into that kind of issue, but the lender's not going to allow a credit for those repair items. The lender's going to require all those items to be taken care of prior to the close of escrow. So if they want a property in tip-top shape and there's concern that way, I would buy new construction. That's the only way that you're going to get that warranty and that guarantee that everything's fresh and clean and new. Otherwise, I would explain to my buyers that they can absolutely submit those to the lender. The lender's going to require each and every item on those inspection reports to be taken care of. And there's a good potential that's going to kill the deal and you're going to be out the additional funds for all those inspections that you did. So it's a better option just to get whatever inspections you want done, completed, and then negotiate those repairs just between you and the seller, not you, lender, and seller. That would be my take on that, but totally up to you. And you're welcome. Q17 is blank fees and costs. So if you've got something else that needs to be factored in there, you could specify it there. Okay, buyers are fun. Yes, they are. Q18 is your home warranty plan chosen by buyer. Coverage includes but is not limited to. So like if you want regular coverage plus like make sure the HVAC system is covered and maybe you want seller's coverage during the escrow period, you would specify that there. That doesn't mean that it's limited to the items there. The buyer can choose additional coverages. Okay, but if we want it to be paid for by the seller, we need to specify what we're wanting the seller to pay for. So here's if you're going to upgrade the package or ask for a 2-year policy instead of a 1-year policy, I would put it here. Who's going to pay for that? The buyer or the seller or both, right? And then if seller or both is checked, seller's cost is not to exceed blank. So we want to put, hey, what's our max cap here that the seller is going to take on by agreeing to this? And we would do it whether the seller's going to pay or you're going to split it. Okay. You're going to put who you want the home warranty issued by. And if the buyer doesn't want a home warranty, you can say, hey, buyer waives the home warranty plan. You could just like leave this blank and then you could decide later that the buyer wants it or that you're going to cover it or whatever that might be. You could do that as well. Okay, so you could leave the whole line item blank. But if we want the seller to pay for it, it needs to be on the residential purchase agreement. R here is the last part of the grid, which is just other terms. So anything else that didn't fit in any of the items above, we can throw down here in R. Okay, when we specify anything else in other terms, I would make sure you are as specific as possible here so that it doesn't leave any room for interpretation. Okay. Any questions there about Q or R? All right. Moving right along. That takes us out of the grid into the rest of the contract. There's not a whole lot in here that I'm going to necessarily cover. There are a couple things, though. The first one is section 4. This is anything else that's going to be attached. Yes.
Sorry, can you go back to the home warranty? So you specified the HVAC and seller coverage.
Yes.
Did you talk about that? Did I blank out?
I just said to make sure that you list here any additional coverages that you want as part of your home warranty. So if you're going to upgrade the home warranty from like the standard plan to the elite plan, we want to mention that. Or if we're going to ask for 2-year coverage and we're going to ask the seller to cover that. We just want to be specific if we're asking the seller to pay for it, what they want, even though it's not limited to. So we can add additional coverages to that. So the buyer could decide that, hey, I want HVAC and seller coverage. And then as they get into the transaction, they're like, oh, look, it offers refrigerator coverage for $60. I'm going to add that to my home warranty. It may exceed what the seller is willing to pay for, but then the buyer is going to pay for that. It's just saying that, hey, we're not limited. Now, if you're asking specifically like, hey, why do you put seller coverage in there? What the heck is that? Number one, I'd recommend talking to your home warranty rep to see if they offer seller's coverage. I like seller's coverage. There's 2 reasons for that. Either as a buyer's agent or a listing agent. Seller's coverage during the escrow period. Let's say that dishwasher stops working. Wah, wah, wah. That never happens during escrow. Things don't stop working. But let's say something did. I've got a home warranty now for the escrow period that's got seller's coverage. So now my seller gets the same benefits as the buyer would. So dishwasher stops working. They call the home warranty, say, hey, dishwasher stopped working. Home warranty is going to either fix it or replace it. Okay, they may not replace it with one quite as nice, but they are going to make sure that there is a dishwasher or a stove or whatever it might be there prior to the close of escrow on whatever's covered, or maybe the HVAC system stops working. That I've had happen more times than not. Now we're getting repair guys out there. So this seller's coverage ensures that that's covered under the home warranty. So whatever would be covered for the buyer is now covered for the seller. As a buyer's agent, why do I like that? I don't really care about the seller because the seller is going to have to replace that dishwasher no matter what. Because when we entered into escrow, there was a working dishwasher, and now we want a working dishwasher at the close of escrow. So I don't really care whether they pay a service fee to get that done or have to pay for a whole new dishwasher. But as a buyer's agent, here's what happens when you have seller's coverage. I've had seller's coverage now on the property for 30 days during the escrow period. Day one, my buyer moves into the property. They start moving stuff in. They're like unpacking their dishes. They're loading the dishwasher. They're going to run stuff through because it's got like newspaper print on all their dishes and little black smudges. And they thought, oh, we'll just run it through the dishwasher. They go to run it through the dishwasher and the dishwasher is no longer working. And it worked during the inspection period. For the most part, the home warranty is now going to cover that dishwasher repair or replacement instead of calling it a pre-existing condition. So when we have seller's coverage on there, generally speaking, I'm not a home warranty rep, but generally speaking, it eliminates the pre-existing condition time period that happens when a buyer moves into a property. So that's why I like seller's coverage on there. It usually runs, I'm going to say $60 for the escrow period. It's $1 and some change, maybe $2 a day. It's not super expensive to add it to the home warranty, and it makes a world of difference after the close of escrow. Adriana, did I answer your question?
Yes. Thank you.
Fabulous. Yes. Make sure Sadie mentioned that home warranties have gone up across the board. So make sure you're writing in. She says $750 or more. I like to actually, when I go to write the contract, I like to go to my home warranty provider and say, hey, here's what we're wanting. What's the cost going to be? Just so I have an accurate cost analysis for what we're asking for. So yeah, make sure it's high enough. If it's not high enough and we've asked the seller to cover, she says she's seen lots of contracts with $500. That's okay. If I was a buyer's agent or listing agent, I would agree to that all day long because I know the buyer is going to have to pay the difference. So if it's $750 for the home warranty, they negotiated $500. I'm expecting buyer's going to pay $250 for whatever they want for the home warranty. So just be aware of that. Christy, whatever you put for your home warranty coverage, that's going to be for the entire home warranty that you're asking to be covered. So seller's coverage and the first year of that home warranty if we're asking just for 1 year. So yeah, so whatever you put in there. Yep, absolutely. Any other questions? All right. Moving right along to section 4. So the grid again is section 3. This is section 4. This is anything we're going to attach to this contract. So things like the tenant occupied property addendums, if it was the TOPA form, if it was a non-seller occupied property or probate purchase agreement, manufactured home purchase addendum, probate agreement purchase addendum, tenancy and common purchase addendum, stock cooperative addendum, mixed use purchase addendum. If we have other addendums, we would check this box and label those here. Backup offer addendum. So if we know they already have an offer in hand, but we want this offer to be reviewed and accepted in backup offer position, we can include that backup offer position addendum. We've got our septic well, propane tank, and property boundaries inspection and allocation of cost. Buyer intent to exchange addendum. So if you're doing a purchase for an investor that's doing a 1031 exchange, we want to include the exchange addendum. Even if it's not going to affect the escrow or anything like that, It's just a document. Buyer has proof that they intended to do a 1031 exchange for this property in case they need that for their paperwork and 1031 exchange professional. You can, just so you know, too, the buyer intent to exchange can contingency, just like the seller's intent to exchange if they're selling a property, can also be part of contingency of the property. So just kind of keep that in mind. We have this disclosure regarding real estate agency relationships always included. We can't uncheck this box. We can't check this box. It's just always there. It's that first document that's attached. We have other addendums, okay, and disclosures. We've got short sales, court confirmation, seller intent to exchange, and then another other line. Okay, so we have our property type addendas. Those would be like your purchase addendums, right? That attach different types of purchases you can do. Our other addendas and disclosures are things that are kind of optional, could go with any of them, short sale, whatever it might be. And then we have buyer and seller advisories. Now keep in mind, so addendums need to be agreed upon by both parties. They need to be signed by both people. Anytime you've got an addendum, when we have an advisory, it does not need to be signed by both parties. Okay, all advisories below are provided for reference purposes only and are not intended to be incorporated into this agreement. You have your buyer's investigation advisory. That one actually only has signature lines for your buyer. Your wire fraud advisory, there's signature lines for both buyer and seller, but because it's an advisory, if our buyer sign it, seller doesn't necessarily have to. Wildfire disaster advisory, trust advisory, REO advisory, fair housing and discrimination advisory, buyer homeowner insurance advisory. If they're checked on here right now, if you're seeing those, your BIA, your WFA, FHDA, and your BHIA, those are all included as part of the purchase agreement. We can't uncheck those boxes. Do not separate them from your purchase agreement. You've got your statewide buyer and seller advisory, your probate advisory, and then you've got other line items there. There's 3 of those other line items. I always, with my offer, include the wildfire disaster advisory. I also include the statewide buyer and seller advisory. I may also include the market conditions advisory, right? But I don't check those and include them as part of the purchase agreement. Those are just advisories for my buyer to be aware of. So I include those, my buyers sign them, but I don't include them as part of the purchase price. So our purchase offer, I would only include them as part of the offer, really, if it's going to change contractually what is going on with the property. So that's section 4. 5 are your items, additional terms affecting purchase price. Now, these are all part of that grid, so I'm not going to cover most of this. There's a few things that I am going to cover here. Let's see here. We talked about that. You've got your buyer is strongly to advised to conduct investigations of the entire property in order to determine its present condition. Sellers and agents may not be aware of all defects, right? So there's that there. Your removal of contingencies. So if we want any details on anything else, this is where we're going to find it. Okay, if we don't have an appraisal contingency. So everything is in here. We talked about, I think it was last week, where to find like what the seller required disclosure. You've got your removal of contingency or cancellation. Okay, all sorts of good stuff in here. I would take time at least once in your life to read through this contract and know it. It's really important and you should know what's in this contract. So make sure you take time. Here is your inspection reports, tests, and certifications. Okay, it states here that, hey, 3Q1, 2, 3, and 5 only determine who is to pay for the inspection report, test, certificate, or service mentioned. It does not determine who is to pay for any work recommended or identified in any such document. Agreements for payments of work, required work should be specified elsewhere. Okay, or in a separate agreement, such as your request for repairs. Any reports in these paragraphs shall be delivered in the time specified in 3N. So just so you know, all inspections and reports required to be handed over to our sellers of the property because now they're material defects of the property. So they're material disclosures. Let's see, reinspection fees. If any repair in paragraph 10B1 is not completed within the time specified and the lender requires an additional inspection to be made, seller shall be responsible for any corresponding reinspection fee. If buyer incurs costs to comply with lender requirements concerning those items, seller should be responsible for those costs. This is why up in the grid, like the time period for installing smoke detectors, carbon monoxide detectors, and water street heater bracing, I put like 3 days because I want it done, or at least in the contractually, it should be done before the appraiser steps foot on that property. Because if there's a reinspection fee, due to the fact that it needs to come back out and reinspect for the appraisal, if we left it the default of 10 days and the appraiser was there on day 5, the seller can be like, well, it wasn't a requirement yet, so that's not my responsibility, that's yours. Okay, so that's why I shortened that time period up. Just so you know here, if you check the box for hey, buyer waives the purchase of a home warranty plan, buyer may still purchase a home warranty plan at buyer's expense prior to the close of escrow. So it doesn't eliminate the buyer from being able to pay for that. It just puts it in the contract. They're not going to. Let's see here. Withholding, pipelines. There's not a whole lot in here besides just making sure that you know what's in here. Cancellation rights here, the time periods, everything has to be in writing. Notice to perform. So remember, our notice to perform is 2 days. Our demand to close escrow is 3 days. Okay. If you wanted to change that, it needs to be in writing as part of the agreement. That is the default. It's set up for 2 days for a notice to perform and 3 days for a demand to close escrow. Here is one paragraph that I really like here. We're in 14H, the effect of cancellation on deposits. Okay, this comes up all the time. If buyer or seller give written notice of cancellation pursuant to rights duly exercised under the terms of the agreement, the parties agree to sign and deliver mutual instructions to cancel the sale and cancel the sale and escrow and release deposits, if any, to the party entitled to the funds, less fees and costs paid by escrow holder on behalf of that party, if required by this agreement, and any escrow fee charged to that party. Fees and costs may be payable to service providers and vendors for services and products provided during escrow. A release of funds will require mutual signed release instruction from the parties, judicial decision, or arbitration award. A party may be subject to a civil penalty of up to $1,000 for refusal to sign cancellation instructions if no good faith dispute exists as to which party is entitled to the deposited funds. Neither agents nor escrow holders are qualified to provide any opinion on whether either party has acted in good faith or which party is entitled to the deposited funds. Buyer and seller are advised to seek the advice of a qualified California real estate attorney regarding the matter. So I like this paragraph because buyer sends over cancellation. I've got a seller that's refusing to sign for the release of the deposit, even though buyers were well within their rights and they had contingencies still in place. This is a good paragraph to just point out, like, hey, you're welcome to do whatever you want. I would recommend talking with a qualified California real estate attorney. Here are 3 that I recommend. But just so you know, if no good faith dispute exists as to who gets the deposit, like they're still within their contractual time frame for being able to cancel, and they're canceling based on the rights that they have. If the buyer decides to pursue legal action, right, you may have to give them an additional $1,000 on top of their deposit. Or hey, buyer, seller, right, you're in breach of contract. We've removed our contingencies. So just so you know, you should talk with a qualified California real estate attorney. I'm not a legal professional, but chances are, because we've removed our contingencies and now you're deciding you don't want to proceed and we've agreed to the liquidated damage clause, chances are the deposit probably should go to the seller just release it and say goodbye to it, because if you don't, it might not only be the deposit that you lose, but your deposit plus $1,000. Okay, so I like this part because usually it gets that cancellation signed if there's pretty obvious who that deposit should go to. Just throwing that out there. So a little note there, 14H, good paragraph to keep on hand. All right, we're going to continue on here through this section, and we're going to talk about the next section that requires some interaction from your buyers, which is the liquidated damage clause. Okay, so liquidated damages, this clause limits the amount that a seller can go after the buyer for. For a seller, it predetermines the amount that they get to keep if the buyer's in breach. Okay, it defaults to, if everybody agrees to the liquidated damage, that if there's a breach of contract, not just buyer cancels, but buyers remove the contingency and now they're canceling, right? Or seller tries to cancel, right? That the seller gets to retain the deposit or 3% of the purchase price, whichever is less. So if our deposit's 1% of the purchase price, buyers are in breach of contract, they cancel, sellers get to retain the full deposit. If our deposit is 5%, this limits it to, hey, it doesn't matter what the deposit was. Seller only gets to retain 3% of that 5% deposit. Okay, this is optional. Buyers can choose or not choose to agree to this, and sellers can agree to or can choose whether they want to agree to this or not. That being said, in clause to be valid, all parties have to agree to it. So just because buyers want the liquidated damage, if sellers don't, then it's not valid and it doesn't apply. Okay. Any questions on liquidated damages? All right. Everybody agrees to mediation. This is not optional here. Mediation is not optional, which means that anytime there's a dispute that arises, if we can't work it out, we're going to go to mediation is our next step. Okay. Let's see here. Mediations are going to be divided equally among the parties involved and shall be recoverable under the prevailing party attorney fees clause. Let's see here. If for any dispute or claim to which this paragraph applies, the mediation paragraph, any party commences legal action without first attempting to resolve the matter through mediation, or before commencement of legal action refuses to mediate after a request has been made, then that party shall not be entitled to recover attorney fees, even if they would otherwise be available to that party in any such action. This mediation provision applies whether or not the arbitration provision is initialed. So mediation always applies. Exclusion from mediation are specified in paragraph 31B, and the obligation to mediate does not preclude the right of either party to seek a preservation of under paragraph 31C, and agents' rights and obligations are further specified in 31D. These terms apply even if the arbitration dispute is not initialed. Okay, so mediation, we're all going to agree to mediate. That's just like coming together with another party who's going to help us work through it, like meeting with a counselor. Okay, mediation applies. So before we seek legal action, we request mediation. Now, this next box, this is arbitration. See how it's got a box around it, just like the liquidated damage. This box is 100% optional. This means that if we agree to the arbitration, that instead of going to like a lawsuit, we're going to go to arbitration panel before a panel of people who understand real estate. Okay, so the parties agree that any dispute or claim in law or entity arising between them out of this agreement or any resulting transaction which is not settled through mediation shall be decided by neutral binding arbitration. The parties also agree to arbitrate any disputes or claims with agents who, in writing, agree to such arbitration prior to or within reasonable time after the dispute or claim presented to the agent. The arbitration should be conducted through any arbitration provider or service mutually agreed to by the parties. The arbitrator should be a retired judge or justice or an attorney with at least 5 years of residential real estate law experience, unless parties mutually agree to a different arbitrator. Enforcement of and any motion to compel arbitration pursuant to this agreement to arbitrate shall be governed by the procedural rules of the Federal Arbitration Act and not the California Arbitration Act, notwithstanding any language seemingly to the contrary in this agreement. The parties shall have the right to discover in accordance with Civil Code procedure blank. The arbitration shall be conducted in accordance with Title IX of Part 3 of the Civil Code procedure. Judgment upon the award of the arbitrators may be entered into any court having jurisdiction. That's just saying that whatever that judgment is can be recorded with the courts. Exclusion. So there are some matters that are excluded from arbitration. These are also excluded from mediation, because remember paragraph 30B mentioned that, hey, everything in 31B, these exclusions apply to mediation as well. So the following matters are excluded from mediation and arbitration. And that's whether this paragraph's initialed or not. Any matter within the jurisdiction of probate, small claims, or bankruptcy court. So if it falls within a probate, bankruptcy, or falls within small claims, we don't have to mediate and arbitrate. We can just file it with that court system. An unlawful detainer action doesn't have to be mediated or arbitrated. And if you're asking what an unlawful detainer action is, that would prevent someone from selling the property out from underneath you while you're going through this process. A judicial or non-judicial foreclosure or other action proceeding to enforce a deed of trust, mortgage, or installment land sale contract as defined in civil code. So if we're going through foreclosure on a property and they foreclose on it during the transaction, we can't go after the seller with mediation and arbitration or anything because it doesn't apply. It is what it is. We can't control the actions of the lender when we are behind on payments. Okay, so all those things are excluded from mediation and arbitration. Preservation of actions, okay, and then, which isn't as important. The agents themselves are not obligated or compelled to mediate or arbitrate unless they agreed to do so in writing. Okay. Any agents participating in mediation or arbitration shall not be deemed a party to this agreement. So our agreement to mediate or arbitrate is a separate agreement that we would need signed at time of like the BRBC or the listing agreement, because our listing agreements and our BRBCs do not specify mediation. Initially in the space below, it's just saying, hey, just heads up, if we initial this, we're agreeing to it. Why would somebody want to agree to arbitration? It was explained to me that the reason that arbitration could be a positive option is that, remember up here, the requirement is for arbitration that it's like a judge or retired judge or a justice that's got at least 5 years of residential real estate experience. So we're being heard before somebody who understands real estate contract law. So that's how it was explained to me. So instead of just going to a jury of your peers, you go before an arbitrator and, generally speaking, an arbitration board. Most of the time when you go to arbitration, there is a panel of, you've got your arbitrator, your person who resides over it, that retired justice with 5 years of real estate experience. And then you have an arbitration board that are real estate agents that have volunteered their time to hear these cases and help make decisions based on contract law. So that's the reason for arbitration. Somebody could decide or not decide. But remember, again, the things that don't fall under there, anything inside of small claims courts, you can just file a claim with small claims courts. You don't have to go to mediation or arbitration for that. Any questions on the liquidated damage clause or mediation or arbitration? Okay, remember, if we don't agree to the liquidated damage clause, it doesn't mean that the seller has no recourse. If the buyer decides to breach the contract and cancel, It just doesn't limit what the seller can go after that buyer for. Okay.
In the liquidated damages, you said that it was optional to sign that or not. Is that
Yep.
also go for the arbitration as well?
Yep. Both boxes
Okay.
there on the page 29 and 31 are optional for our buyers to sign,
Okay. Thank you.
and optionals for the sellers to agree to as well. But again, both of them agreed to by all parties for them to be valid. So buyer agreeing to arbitration and liquidated damage, seller not agreeing to it means it's invalid. And generally speaking, we want to clarify that as part of the counter offer, that we get everybody to agree that buyer sent the purchase contract in with these paragraphs initialed. Seller doesn't want to agree to liquidated damage. We're going to counter the buyer that the seller does not agree to the liquidated damage clause. And therefore it's not part of this contract, and then the buyer to accept that counter offer, so that we have everybody in agreement at some place that, hey, it's not part of this contract, just so there's a clear understanding. All right. Last page of this offer, or I guess the second to last page, is where our buyers sign it. This is the same as the BRBC, where we've got an expiration of offer that we already put up in the grid. We have our entity buyers. So if we have buyers purchasing as a trust or an LLC or corporation or whatnot, we would want to check this box here. We're going to put the full entity name. So this would be like the Amy Pittard Living Trust. Okay, so we're going to put the full name of whatever it is there, or maybe I'm purchasing it as the Amy Pittard LLC. Okay, and then we're going to identify down here who the legally authorized signers are. So this would just be Amy Pittard. I own that LLC all by myself. Okay, and then down here, printed name of legally authorized signer. And because it's an LLC, I might say like owner or president. Okay, whatever your role is, or that role is. If it was a trust, so it was the Amy Pittard Living Trust, then instead of a president, I might be a trustee. Okay, and if there was more than one trustee, now I just became a co-trustee. Okay, so that's how that works there. Cancel. I don't know why it's trying to make me leave the, don't sign me out. It says timed out. Okay, hopefully that worked. Okay, so that's how that works. If we don't have an entity, it's just a regular buyer, which for most of our transactions, it's just a buyer. Then it would just be buyer's one name here. There would be no title. They're going to sign and date, and then buyer two. Okay, acceptance. Seller has multiple options here for acceptance. They can submit a seller counter offer. They can do a backup offer addendum. So maybe they like your offer, but they already have one and there wasn't a backup offer. Maybe it's like they received multiple offers. They accepted one, and then we're saying, hey, Amy, we're going to send your buyer a backup offer addendum because we like your offer, and we're going to lock you in as the second buyer in case something happens with our first buyer. And then we have, if the seller is an entity seller, it gets filled out the same way we just did for the buyers. If the seller is a trust or a LLC or a corporation, or if it's a probate situation or whatever that might be. And then sellers sign here. So whatever the option is here, we check that box. If we don't check any of these boxes, so if we don't offer the backup offer, then we're accepting the offer. So if we don't check those boxes and we sign down here, we are accepting it. Super important, because if we don't check the box that there's a counter offer and we just sign this and send it back with that counter offer, we've accepted the offer without the counter offer that we've submitted to the buyers. Last page is where we sign. So this is where you make sure that you have your brokerage, the license number, your name, the license number, the address, the email address that you want to use for electronic delivery, and your telephone number. If there's more than one agent from the same firm representing the buyer, we would include the additional agent acknowledgement. We covered that in May, I believe, maybe June. Might have been June. We covered it in June. And then if there's more than one brokerage firm representing the buyer, that'd be the ABA, the additional brokerage acknowledgement. So for more than one agent, we check this box. More than one brokerage, we check the second box. Designated electronic delivery address defaults to the email above. Okay, defaults up there. If we want it to be a different email, we would put that in on this line item. And then the attached DEDA. If parties elect to have alternate delivery method, such method may be indicated by car form DEDA. So if we aren't okay with electronic delivery, we want forms manually handed to us or mailed to us, we're going to use this DEDA. I don't recommend that. It's going to make things really complicated. Okay. WPI. All right. Any questions about that? And then the seller has the same options there as well. Any questions about this so far? Last section here is the escrow holder acknowledgement. Usually leave this blank until we get accepted contract, and then we send this over to the escrow holder. They stamp it with their information, and then they sign it, and then it's completed. But other than that, I usually leave this box blank. Seller's brokerage firm presented this offer to seller. If we want proof of presentation, we would the agent or the seller initials here on the date that it was presented to their client. And if the offer is not accepted, so we didn't counter offer, we don't want to keep it in backup offer position, we just want to reject it, seller can initial here, no counter offer being made. This offer was not accepted by the seller on blank date. So if we want proof of rejection, we would get this section completed by the seller. Any questions about the residential purchase agreement? All right, attached to our purchase agreement, we have the Fair Housing and Discrimination Advisory. Please do not discriminate in real estate on any of the protected classes. Do not discriminate at all. Wah, wah, wah. And this is just an advisory letting them know that you're not allowed to discriminate. And if they felt like they were discriminated against, where they could go to file a complaint. It's 2 pages. There's no exceptions or limits to that in the sale of residential property. By licensed real estate professionals. You've got your buyer's homeowners insurance advisory here, your BHIA, talking about the importance of obtaining property insurance, talking about property insurance and purchase contract terms, that we have the property insurance contingency in that contract. California's property insurance market is difficult. Good luck finding insurance. Insurance conditions, that there might be physical condition standards or they're willing to issue a policy. Could be like the prohibition of knob and tube electrical wiring, requirements related to plumbing or piping materials, standards related to the age or quality of the roof or foundation, minimum safety standards related to handrails, tripping hazards, and defensible space requirements. Okay, so just be aware of that. And then resources for if you need help with that, insurance information, and then broker recommendations that, you know, hey, we're advised to explore availability of property insurance options early in the home buying process. Consult with a qualified real estate or insurance professional, not real estate professional, of buyers choosing to understand insurance availability and cost prior to removal of contingencies and any related contingencies. We don't have expertise in this area, so that's your homeowner's insurance advisory. Then there's the wire fraud and electronic funds transfer advisory. Please, buyers, never transfer funds to anybody without confirming. The only people that you would ever transfer funds to is title and escrow. If you get a notice to wire money to them, I want you to call this number right here before you wire any funds. Please confirm with title that they have made the request. They did not, because they will not send you a request to wire funds. Okay, so that's your electronic funds, wire fraud and electronic funds transfer advisory. You have your buyer investigation advisory that talks about some of the ways that buyers can investigate the property, what their obligations are, the importance of property investigation, and advising them to investigate the condition and suitability of all aspects of the property, including but not limited to the following. If you don't do so, you're acting against the advice of the brokers. And then it lists a whole bunch of different types of investigations they can do. We always recommend 5 investigations. I hope that's right. Home inspection. All my buyers get recommended. They get a home inspection, a pest inspection, a roof inspection, an HVAC inspection, and a sewer lateral inspection. Okay. Those are the 5 areas where we make sure that we get the most coverage. I have an email that actually goes out to my buyers that specify that, hey, this is what we recommend. If you think of something that's not covered by these that you want inspected, please let me know. Okay, I have inspectors that I can recommend to you, or you can pick your own. It's totally up to you. Again, we always want to recommend 3, let the buyer choose. And we need to keep in mind too that when we are making an offer on a property and we're talking with our buyer about investigations, that we've got to take it property by property. So I have my 5 basic ones. Obviously, if there's no HVAC system, we don't make an HVAC inspection, so I don't make that a recommendation, but most properties do have HVAC of some sort. But if it had a pool, I would recommend the pool inspection. If it was on the side of a hill, I might recommend a soil stability inspection to make sure that the house isn't going to slide down the mountain. If it's got a lot of trees, we may want to recommend that there's an arborist that comes out to look at the trees to make sure that they're healthy and they're not going to fall on the house. So it's our job to make these recommendations to our buyers. They've got a list here. They've got the statewide buyer and seller advisory that's a more complete list of inspections and investigations, but we always want to make sure that we're making recommendations to our buyers, so that they stay on top of things and that they make sure that their interests were taken care of and that we did our job. Again, it's not our job to do the investigation. It's just saying, hey, we may want to be aware or check out this or have this person come out, and always make recommendations. So that's the last page of, oh no, we have one. Oh, only because I added more. So that's the last attached page for the residential purchase agreement. So we had the agency disclosure at the beginning of the residential purchase agreement. We have our buyer investigation advisory. We have our wire fraud and electronic funds transfer advisory. We have our buyer insurance, homeowners insurance advisory, fair housing and discrimination advisory, and then our purchase agreements. Any questions before we wrap up today? It's 10:07. Thanks for hanging with me. I know I went a few minutes over. I apologize for that. Christy, you are welcome. I'd say bye to Sadie, but she's already gone. Or
Amy,
she's on mute.
when will these be available? I missed last week. When will it be available?
It usually takes us about a week to get them cleaned up and then reposted. If you subscribe to the YouTube account, I think you should get notified when they come out. And then we're also, if you subscribe to our Substack, which is where we're kind of transitioning the video library to, is over to Substack, then you'll get notified anytime a new video is added so you can know when it comes out. We also update the spreadsheet as well.
Great, thank you.
Absolutely. Next week, we'll pick up with some of those other forms that we've discussed over the past 3 weeks of the residential purchase agreement, things like the IDA and the FVAC and the HID and the SFA and the COP and the SIP and the RLAS. So we'll start digging into some of those associated buyer forms. If you have anything specifically that's buyer related that you want me to cover, just shoot me over a message and I'll make sure to get it covered before we move on to our seller forms. We'll see you next week.